Good afternoon, everybody. Welcome back to State Law Library CLE. I'm delighted to have our speakers back with us. Some of you might have heard them speak when they were here earlier in the year. Before I get started introducing our speakers, I just want to let our people who are on the webinar know that if you have questions, use the chat feature to type them in. And because there is a lot of material to cover, we are going to wait and have questions at the end. So if you have those, just if you could hang on to them, that would be great. Both of our speakers today are from the Jacobson Law Group. We have Joe Halloran, who is right here, and Joe represents tribes in a broad array of matters, including litigation, cultural resources protection, real property, intellectual property, governance, regulation, business and finance, legislative affairs, gaming, and also Indian child welfare. His bio is very replete with wonderful things that he's done. He also has taught Indian law at Willie Mitchell and has presented numerous CLEs on the topic of Indian law. He has served as an in-house general counsel and is a qualified neutral mediator and arbitrator under Rule 114. He is also a special member of the Minnesota Indian Bar Association, and he is a graduate of Willie Mitchell. Michael Murphy, who is over to my far left, joined the Jacobson Law Firm in 2014 after serving as a public defender for the Regional Native Public Defense Corporation in northern Minnesota. Prior to that work, he served as the 2012-2013 Fulbright Scholar in Law to Papua New Guinea and consulted for the World-based International Finance Corporation. While in law school, he served as a legal intern for the United States Department of the Interior. He helped develop the Legal Assistance for Native Families Clinic, serving Native American clients in the Twin Cities and central Minnesota, and also was conducted research for Willie Mitchell's Indian Law Program. He is also he's also a qualified neutral under Rule 114, and he continues to do ADR work in Indian country for the firm, and he also got his law degree from Willie Mitchell. So please help me welcome our speakers today.
I'm going to put a little stopwatch up here so that I can make sure that I stay on point so Michael has time to do his presentation as well. Thanks everybody for coming. The last time we were here in March, thank you for coming again, Justice Aloha, for condolences. We were speaking about the source and exercise of tribal sovereign authority through their court systems, and gave you an overview and backdrop for the source of that authority and what one might expect when practicing in tribal courts. When we wrapped up the presentation, we noted that there were two decisions outstanding in the United States Supreme Court that could impact the parameters, the boundaries of tribal court jurisdiction. One was Dollar General Store versus the Mississippi Band of Choctaw Indians. That's in the civil context, and then United States versus Bryant, which is fell in the criminal context. And so Liz invited us to come back now that decisions have been issued in both those cases to give you a quick update on the decisions of the court and how that affects what we spoke about last March. So if you could. So I'm going to give you a quick background. Again, I apologize, in an hour time, 25 minutes allotted to me, you're going to get a fairly high-level walkthrough of the cases leading up to and informing Dollar General, the decisions in Dollar General, including the Supreme Court decision, and then some practical implications for what that Supreme Court decision means. And so I'll take you through, we'll get to Dollar General, but in order for Dollar General and the importance of the question posed really to mean anything, I'll take you through the Supreme Court precedent that shaped the question presented to the U.S. Supreme Court. And then we'll talk about the Supreme Court's Curium Decision and the implications. So let's start with Montana versus the United States. a 1981 decision. The Supreme Court really hasn't revisited what became the Montana test out of this decision in 35 years. The Plains Commerce decision, as you'll see, came in 2008, but the plaintiffs in the Fifth Circuit decision and the Fifth Circuit decision itself indicated that it was the Fifth Circuit's decision that Plains Commerce really didn't change much about how the Montana test is applied and what it means. And the circuits also are largely, they have moved forward with the Montana test, not drilling down in any particular way to further either contract tribal court jurisdiction or, if you will, expand any exception to tribal court jurisdiction over conduct in Indian country. So really what we're speaking about is what jurisdiction does the tribal court have to exercise over non-Indian conduct in Indian country, and that includes, especially in Montana and in Plains Commerce, fee land located within a reservation. And to fast forward, the issue that was raised in Dollar General that really got everyone's attention was a question about the implications of Montana, and our fear was the extension of a Montana test to conduct that everyone agreed occurred on trust property pursuant to a lease with the tribe and a business license issued by the tribe. So let's quick back up and take a look at Montana. I'm hoping, even though that this is going to be a fairly high-level review of these cases, that you'll end up with in the 99th percentile of knowledge of the basics of tribal court jurisdiction over non-Indians when we're done here. The Crow tribe sought to regulate conduct of non-Indians hunting and fishing on tribal land located on their reservation, and particularly including conduct on the Bighorn River. The Ninth Circuit, the tribe's assertion of jurisdiction was challenged by the state in federal district court and was affirmed, and that jurisdiction was largely affirmed by the Ninth Circuit on appeal. So the Supreme Court granted cert, and it reversed, establishing what is a two-pronged test for assessing tribal jurisdiction over non-member conduct in Indian country, which has become known in parlance as the Montana test, two-part Montana test. So the underpinnings of the Montana test, I think it's important to keep in mind that when Montana was issued, it came on the heels of the decision of the U.S. Supreme Court in Oliphant. Justice Rehnquist issued that decision in the criminal context and concluded that one of the restrictions on retained inherent tribal sovereignty was the authority and jurisdiction of tribes to exercise criminal jurisdiction over non-Indians. Later, the Dura decision was issued, which extended the reasoning in Oliphant to include non-member Indians within the definition of non-Indians, and it excluded tribes or precluded tribes from exercising jurisdiction over non-member Indians under the Oliphant decision. That decision was later legislatively fixed by what has become known as the Dura fix that restored tribal criminal jurisdiction over non-member Indians. So it's important that we view this decision in that context, because while the 70s and early 80s were fairly high time for the Supreme Court in issuing decisions regarding self-determination, we were already a decade or longer into President Nixon's federal period of self-determination and the goal of enhancing tribal self-determination and exercise of sovereign authority. The Supreme Court, however, issued several decisions which really constricted the exercise of tribal jurisdiction, and in one of those ways was Oliphant, and Montana fell within that period. So the court indicates, as the quote reflects, that it was extending the notion, the concepts discussed in Oliphant to the civil context, and acknowledged that tribes retained inherent sovereign power to exercise civil jurisdiction over non-Indians, but that it had to be in a way that implicated the role of the government and the sovereign authority of the tribal government through consensual relationships, taxing and regulatory arrangements, and the like. And so these underpinnings led to the two-part test, which interestingly, one of the reasons I pointed out that cert grant and Dollar General was raised a lot of eyebrows is because Montana was consistently viewed as a limitation on the tribe's authority to exercise jurisdiction over non-Indian conduct on fee land. And for those of you who aren't familiar with the reservation system of land title, with the exception of Red Lake and the Net Lake Reservation of the Boys Fort Band, the rest of the reservations in Minnesota during the late 1800s were allotted. Once tribal members were granted allotments, it was part of a way of really sort of slowly bringing an end to tribal governmental authority and tribalism by allotting land to individuals within the reservation. When those allotments were made, the lands were opened up for settlement by homesteaders. They entered under the Homestead Act, sale to timber companies and railroads. And when reorganization happened in '34, and the importance of tribal governments was reinvigorated, and lands were acquired for tribes to hold as tribal land for the benefit of all members, you ended up with a jurisdictional, it's often called jigsaw puzzle or checkerboard, where reservations may have a boundary like Leech Lake, White Earth, which were heavily allotted, but that within that boundary there were fee lands held for generations by non-Indians, surrounded by quite a bit of tribal land. And so the question becomes, where does the rubber hit the road when the tribe wants to exercise, for example, environmental regulations, water quality regulations, hunting and fishing regulations, reservation-wide? And that was the nature of the challenge in Montana. And so the court in Montana set up a two-part test for these to address non-member conduct on fee lands, and that tribes would have jurisdiction. Well, first of all, the court pointed out that tribes were presumed under Oliphant et al. Not to have jurisdiction over non-member conduct in Indian country. But then it established this two-part test that said, except in circumstances where non-members enter into a consensual relationship with a tribe that subjects them to jurisdiction, or the conduct of the non-member threatens the political integrity, economic security, health, or welfare of the tribe. Those are the two parts. So Montana ruled the day as the analytic framework for this analysis for 27 years. And then comes Plains Commerce. Now Plains Commerce arose out of the Cheyenne River Indian Reservation in South Dakota, a reservation that also had been allotted. So the case came up after a challenge in the federal district court came up through the 8th Circuit. Now, what had occurred was that there was a fee parcel within the Cheyenne Indian reservation that had been farmed for years by non-Indians, and then later by tribal members. And the sale was never offered to the tribal members, and then the property was sold to non-members, and the tribe challenged the sale of the property within its reservation. Plains Commerce had the bank interest in the property and challenged, and the district court 8th Circuit found tribal jurisdiction under Montana's consensual relationship exception, holding that the tribe had the authority generally to regulate business conduct of persons voluntarily dealing with tribal members. And to this point, the land had been the subject of a voluntary farm lease to tribal member Indians. And the claim was one of racial discrimination, was the basis for the claim in Plains Commerce. And so the 8th Circuit affirmed jurisdiction for the tribal members' challenge to the sale of the fee land within the reservation. The next, there we go. The Supreme Court took cert and it reversed the holding and held instead that Montana did not permit tribes to regulate the sale of non-Indian fee land located within the reservation. But the court went on to point out that Montana and its progeny permits a tribal regulation of non-member conduct inside a reservation that implicates the tribe's sovereign interest. And the court concluded that while there were circumstances where conduct on fee land within a reservation could certainly rise to that level, it did not in the context of the sale of fee land on the open market, just because that land was located within the reservation. So Plains Commerce takes us through 2008, and so the distinction between the sale of land and conduct on it was important to the court, and as I indicated, the court said that while tribes generally have no interest in regulating the conduct of non-members, then they may regulate non-member behavior that implicates those retained inherent sovereign rights to internal governance and the maintenance of internal relations within the tribe. So we move forward from Plains Commerce and we come to Dollar General. Now, Plains Commerce was already on the books when Dollar General was unfolding. I'll get to the implications later, but one of the real implications, I think, from the Dollar General case is look at the time that lapsed. The conduct that was complained of in Dollar General occurred in 2003. The claim was filed in 2005, federal district court review in 2008, and a Supreme Court decision in 2016. So I don't mean to jump ahead, but the end of the story, the butler doesn't know. The end of the story is that these parties haven't begun their discovery and litigation, and we're 13 years past the time of the incident. So Dollar General very, very quickly, they operate a store on the Mississippi Choctaw Reservation in Mississippi on land that's held by the United States in trust for the tribe. And they built their store, since you can't encumber trust land, the typical way for doing economic development in Indian country for non-Indian business is to take a long-term leasehold, and the debt for building and operating the facility is secured by an encumbrance, a mortgage of the leasehold. You can't mortgage the underlying trust title. And so Dollar General had a lease with the tribe, and it also had been issued a business license by the tribe under the tribe's business licensing ordinance. Both are required for this project to go forward. And under the lease, the tribal court was identified as the exclusive venue for disputes related to the lease. Again, we'll talk about specificity in the identification of venue and what does a dispute arising under the lease mean. The parties had very different views of that. So Dollar General participated in a program that the band had developed, a youth initiative program, where it placed tribal member youth with businesses on the reservation to help them train for business skills and to get some experience in the business world. The tribe is called the Youth Opportunity Program, and Dollar General participated in that program. And in 2003, John Doe, who was a 13-year-old tribal member, was assigned to Dollar General under this program. And while assigned to that program and working at the store, he was allegedly sexually molested by the manager of the store, an employee of Dollar General. So procedural background, the plaintiffs filed suit, as I indicated, in 2005 in tribal court alleging a tort and tort remedies. The tribal court found jurisdiction under both prongs of Montana test. So consensual relationship and conduct that implicates the interests of the tribe. Dollar General appealed to the tribal Supreme Court, which affirmed tribal court jurisdiction. In 2008, Dollar General brought action in federal district court challenging the assertion of tribal court jurisdiction over the entity. And as you all, I'm sure, well know, the exercise of tribal jurisdiction over non-member Indians creates a federal question. Tribes are not residents of any state for the purpose of diversity jurisdiction. This was a federal question jurisdiction. And the tribe and Dollar General filed cross motions for summary judgment, and the court denied Dollar General's and granted the tribe's motion for summary judgment in a decision reported at 846 F sub 2nd. Sorry for the E on the end there. 646, concluding that the tribe had jurisdiction through the business relationships as a result of the business relationships between Dollar General and the tribe. DG appealed to the Fifth Circuit, which again affirmed. And in the Fifth Circuit's decision, it made a couple of important analyses that are significant because the Supreme Court's decision results in no change of the Fifth Circuit opinion. So the Fifth Circuit opinion is the law of the Fifth Circuit. I found particularly interesting and I mentioned the context for Montana and Oliphant as sort of in a period of contracting external authority of tribes on the court, and in comparison to the Fifth Circuit decision, which is very much a case that it uses as a backdrop the period of self-determination and the decisions out of the Supreme Court in Iowa Mutual and other decisions, which point that the exercise of tribal court jurisdiction is an important way of advancing the self-determination of tribes. The court made the nexus determination, that consensual nexus determination, that the tribe could regulate the conduct of Dollar General to protect the safety of minor member children in the workplace. The interest that it took at a much higher level, at sort of a 30,000-foot view, was the tribe's interest is implicated because it has a responsibility to make sure that the workplaces on its reservation are safe. Dollar General had in turn argued for a very narrow construction of the nexus analysis, suggesting that the tribe needed to demonstrate that that particular tort conduct against that child implicated a self-governance or inherent sovereign authority of the tribe, and that it really couldn't do that, and that the consensual relationship evidenced by the lease and the business license were too attenuated from the tort conduct, essentially a superseding intervening cause that separated, that separates liability in our tort world, but also sort of separates, in their view, that nexus, that consensual relationship to the actual conduct over which the court was exercising jurisdiction. So, so by this point we have tribal trial court, tribal Supreme Court, federal district court, and Fifth Circuit, all pretty much in agreement. There was a dissent in the Fifth Circuit, I will grant you, but all of these levels of review that found, by applying Montana, that we don't need to do any extraordinary gymnastics in order to apply the two-part test and come to a conclusion about jurisdiction. And then the Supreme Court granted cert, which made everybody wonder what was going on. So the question presented to the court was whether tribal courts have jurisdiction to adjudicate civil tort claims against non-members, including as a means of regulating the conduct of non-members who enter into consensual relationship with the tribe or its members. Dollar General asked the court to revisit the Montana test, and Dollar General specifically continued to pursue the nexus between the consensual relationship and the conduct over which the tribal court was exercising authority. To really, I would say, the way I look at it was to take the language of Plains Commerce and to kick it open. That the door was, in their view, the door was opened a bit to the constriction of what the consensual relationship will justify in the way of exercise of jurisdiction, and to open it up pretty broadly so that there would be particular connections that would have to be made between whatever conduct it was that was the subject of the civil suit and directly to that consensual relationship. Their argument was several, one of which was the leasehold didn't commit the tort, in essence. The business license didn't commit the tort. and went so far as to argue that there was off-reservation conduct that was implicated in the tribal court lawsuit, including the training and supervision of the tortfeasor, that didn't occur on the reservation, didn't occur as a result of the lease, and didn't occur as the result of the business license. So that was the point really of the Dollar General argument was to really, I don't know how to say it properly either, to open up that consensual relationship, or conversely to constrict the circumstances under which consensual relationship can be shown to justify jurisdiction. So the case is granted in cert. At the time the case was granted, Justice Scalia was alive and serving on the court. I think the sense in Indian country was concern, not only because of the argument that was advanced in Plains Commerce and advanced before the Fifth Circuit to make that constriction, but also because, as we pointed out, Dollar General, the tort in the Dollar General case occurred on a leasehold of tribal trust lands. And the common wisdom of applying the Montana test at that point was you applied it to non-member conduct on fee land. So the question was, where are we going with this? Is this an extension of Montana to cover any exercise of jurisdiction over non-member, whether on fee or trust land? Are we going to get a Supreme Court affirmation of the expanded notion of Plains Commerce? And to that point, as a sidebar, to that point, the courts that had applied Plains Commerce and the Montana test between 2008 and when the Supreme Court granted cert did not adopt the argument, the take of Dollar General on the expansion of the consensual relationship nexus. They had simply applied Montana, and universally in the cases cited after Plains Commerce had found tribal court jurisdiction based on a consensual relationship, like the leasehold in Dollar General. So where are we at here? Next one. There we go. Yeah. Interestingly, also, as a little sidebar, I point out, Montana talked about the exercise of tribal court jurisdiction in 1981. Tribal courts in 1981 were significantly different than tribal courts in 2016. And I think that one of the things that you see, really a couple of things that you see, is business interests that are concerned about robust tribal courts that now have funding of their own source to develop systems to exercise jurisdiction that they didn't previously have the resources to exercise, and to defend jurisdictional assertions where they previously didn't have the resources to defend that jurisdiction. So I think that the change in the interest in Montana in 2016 is interesting in that it indicates a healthy and robust tribal court system in the United States. I think I mentioned the amici in the case because I think it also indicates that it isn't tribes against the world in the context of assertion of tribal court jurisdiction. I think one of the things that has happened is states and tribes, as they have in Minnesota, have formed intergovernmental jurisdictional committees and panels to work out jurisdictional issues. Tribes have taken on significant child welfare caseload, health and wellness court caseload, some domestic violence caseload, and states like that, counties like that. The resources, the limited resources that state court system has had to survive on are more available to the state courts because tribal courts are exercising their own jurisdiction over their own people that used to be in the state system. And so what you'll see is states were on both sides of this case. Oklahoma on the side of the petitioner is not surprising, or Wyoming or Utah. Michigan is a little surprising, but the rest of them really were not all that surprising. But if you look, the state of Mississippi itself sided on behalf of Mississippi Band of Choctaw, which I think reflects a very healthy intergovernmental relationship between the two sovereigns. So I really probably could have stood up here and given you the background of the last presentation and said, so what did the Supreme Court decision do? And I could have sat down by just simply saying nothing. By the time the Supreme Court issued its decision, Justice Scalia, God rest his soul, had passed. And the court was comprised of 8 justices. The seat had not been filled, and the court was hopelessly deadlocked in a 4-4 opinion. There was no opinion. And so a per curiam order was issued June 23rd. And that means, for all practical purposes, that the Fifth Circuit decision stands, the decisions in the other circuits that have applied Plains Commerce in interpreting Montana stand, and Montana remains now, 35 years after its decision, the 2-part test that really informs and defines an analysis of jurisdiction over non-Indians in Indian country. Many feel that, I must admit there was a sigh of relief in Indian country because of the concern about what the cert grant meant, but I don't know that it was universal glee, because I think both tribes and their business partners were wanting some resolution of what Plains Commerce meant. The Fifth Circuit notably said, well, Plains Commerce, very simply rejecting Dollar General's analysis, said Plains Commerce applied Montana and said that the tribe didn't have jurisdiction over a fee parcel. No big deal. And to the extent the Supreme Court went further and said that it could imagine circumstances in which the conduct could arise to the level that it would implicate tribal interests and support an exercise of jurisdiction, the Supreme Court said that's dicta. It wasn't the basis for the decision, and it doesn't really inform anything. And so the reading tea leaves of a decision, of dicta in a decision in the Fifth Circuit's view was not helpful, and it wasn't willing to go there. It applied Montana straight on, and it applied Plains Commerce as having done a fairly straightforward application of Montana in the case. And then, by contrast, the Fifth Circuit concluded that it couldn't imagine a circumstance in which there would be more connection, more directly related to an interest that the tribe has to protect its youth in employment situations on trust land under an agreed-to program on a leasehold issued by the tribe and subject to a business lease. There's a lot of layers that the Fifth Circuit found that it was unwilling to further entertain Dollar General's attempt to constrain that nexus test. So what I wanted to point out following the decision is subsequent proceedings. I'm waiting to hear from my colleague and friend at the Mississippi Choctaw Court to find out the status of the court proceedings, and if that comes up, I'll let you know. But remember, these parties haven't even done discovery. 13 years after the tort, they fought about jurisdiction. And I found it particularly ironic. I was mentioning to Michael on the way up here that the Bankers Association in South Dakota participated as an amicus in support of the Dollar General. And I said to him, well, what do bankers want more than anything? I mean, well, second to money, certainty. They want certainty and efficiency. They want to know where they're going to go, how disputes are going to be resolved, and to get them done quickly, because time and lawyers costs a lot and cuts into capital for projects and really can chill development. And they want to lend money. 13 years later, these parties have finally decided the shape of the table. And I can't imagine what the legal bills were, but I can guarantee you they weren't small. The lawyers on both sides were numerous, excellent lawyers from big firms, and I imagine that 13 years of litigation was quite a bill. So I wanted to share with you where they will be going, because this sort of brings full circle the conversation we were having in March about tribal court systems and thinking about practice before a tribal court and what they maybe look like and what Dollar General so terribly feared. This slide shows the Mississippi Choctaw judicial center built in 2007. It's often said that the only thing that they forgot was the gold leafing on the toilet seats. It is a state-of-the-art institution. It houses the court, their legal defense, satellite office for the tribal attorney general, offices for federal magistrate, U.S. Marshal, U.S. Attorney. It's less than a decade old. Beautiful facility. The structure of the court, it has 4 separate courts: civil, criminal, youth, and their peacemaker court. And peacemaker court is a real a dynamic development in Indian country that really institutionalizes mediation in a traditional way. And civil cases, juvenile cases, inappropriate circumstances, maybe domestic cases, but that's iffy, can refer themselves to a peacemaker model, go through a mediation, and that is reported internally to the district court and is then reduced to essentially consent judgment. And the court has regular civil, and in the civil division it has regular civil division cases and small claims cases. And the code has 32 titles, rules of procedure, criminal code, individual titles covering every manner of law that you would need to apply in the court. And that code is fully available to the public on the tribal court's website. The court itself is comprised of 9 judges, 12 staff. You have a court administrator, 8 clerks, and a Supreme Court with 3 justices, a Chief Justice who heads the overall court, and then 2 other justices that appear on an as-needed basis for appellate panels. In addition, the docket. I didn't get the Mississippi court, county court data before I came here. My apologies, but this is a court with a very, very active docket. Thousands of cases. I mean, closer to 10,000 than to 1,000 of cases processed annually. And that is not quite a 50-50 split, but it is about a 60-40 split, closer to a 60-40 split between criminal and civil cases. So the experience of the court that the parties will be going to is there. The docket reflects a very active court with an experienced judiciary, available law, and a well-trained and robust staff. So again, I will let you know whether they have actually engaged in even discovery yet, but that is where the proceeding will go, because with the per curiam decision, obviously the matter would be remanded through the 5th Circuit down to the district court and then back to the tribal court, and the tribal court would pick things up where it left off, which was the conclusion of Rule 12 pleading. I'm not even sure whether Dollar General interposed an answer. I think their initial, I think they filed a pre-answer equivalent of a Rule 12 motion for dismissal. So some practical considerations. The implications of per curiam decision, I think I've covered. It hasn't resolved this issue, and let's be honest about it. What would have happened with a 5-4 court that took cert, we don't know. But it is also likely that with an appointment made in very early next year, and assuming confirmation, we will get back to a full court, and I would imagine that the business interests that lined up behind Dollar General will be looking for an opportunity to take this challenge back up to what had been a willing Supreme Court for its review and a reconsideration of the Plains Commerce decision and how that informs Montana. I think also that that it's important to consider the lessons learned from the facts and the case analysis. I spoke about how the lease vested venue in the tribal court to resolve disputes arising as a result of the lease. As you get out into practice or are in practice and you have a transaction with a tribe or you are counsel for a tribe, I think that the Dollar General case indicates probably most of all that it is expensive to be vague in a venue provision, especially where you may end up with an unwilling defendant. And so speaking directly in the transaction documents as to what the consent means, what it captures, and whether challenges to that will be allowed at the conclusion of proceedings, the exhaustion of remedies, and precluding a pre-adjudication challenge. Those kinds of things can be laid out in your transaction documents. It's between the tribe and the tribe's business partner. The tribe and their business partners won't always agree. And there are some times where business deals don't happen because tribes stick pretty tight to their jurisdictional analysis, jurisdictional position, and the business decides it isn't willing to do that. But unless you have a sole source for the business deal, that's the marketplace. There are plenty of businesses that will. Banks, institutional banks are all over in Indian country, and they're financing all kinds of economic development, not just casino related, but developing other economic infrastructure for tribes in Indian country. So be particular. I mentioned business licensing because that also really didn't get teased out in the decisions, and I haven't seen the business license, but what it tells me is it was a license. They applied, they said what they wanted to do, they got a license, and there was likely no provision in the license and the application speaking to the submission of the licensee to tribal court jurisdiction for the resolution of disputes arising under the conduct authorized under the license. If that had been the case, I think the decisions would have been shorter and the resolution may have been quicker. And then again, 13 years since the alleged conduct, 8 years since the lawsuit was filed. The 13-year-old is now 26. Witnesses are 13 years older. What are the records retention policies for the company and the tribe? Was there a hold memo issued? Has that stuff been preserved? There are all kinds of problems with resolving this issue, just setting aside the fact that these parties have been committing just enormous capital, human and financial capital, to a fight about what judge they're going to argue in front of. And so the lessons learned regarding tying down these jurisdictional submission provisions and speaking to the requisite nexus between the relationship and the covered conduct really is designed to get at not having over a decade expire without a party who alleges a tort at least getting a ruling for or against. Did I have anything else, Michael? There we go. I'll be available for questions, and then I'll keep an eye on the status of the tribal court. Thank you.
Did I really go to 23? Oh, yes. Did I just should take questions? Okay. You should go ahead. I'll do a brief. We'll do a wide overview here. I think that it bears consideration that the 2015 term of the Supreme Court was really had some incredible decisions come out, and in terms of tribal interests, and the 2015 term did generate a fair bit of anxiety, not just in the sphere of tribal court and the exercise of jurisdiction over individuals in court, but also broader ramifications as well. But having a civil case and a criminal case before the court in the same term and have the decisions come out the way that they did certainly did generate a sigh of relief, I think, for tribal court interests. This case, United States v. Bryant, was particularly interesting because it represented the first constitutional challenge to the Violence Against Women Act, which was specifically passed to address really an epidemic of domestic violence that's occurring in Indian country because of some circumstances that that this case really illuminates, and the court does go into to describing what that is. So to start, the question that was before the court was whether or not the United States attorneys could use an uncounseled tribal court conviction to establish a prior crimes predicate of a portion of the Violence Against Women Act, which basically federally criminalize repeat offenders who commit crimes of domestic violence. And essentially there was a circuit split because the Ninth Circuit said that there was a Sixth Amendment violation. The 8th and 10th previously found no Sixth Amendment violation, and so the Supreme Court granted cert to resolve the split. There was a unanimous holding by the court, and authored by Justice Ginsburg, and the court essentially found that tribal court convictions that were valid when obtained retain their validity for the purposes of Section 117A prosecution. So the legal bases that the court really relied on are kind of aspects of the court decision that really kind of give a broad fundamental understanding of the courts, tribal courts, and kind of their exercise of criminal jurisdiction in these contexts. I have some notes here. So, I mean, the overriding situation here was that Bryant's defender relied on a case, Scott v. Illinois, as you all probably know. It's a 1978 decision that found that the Sixth Amendment guarantees indigent defendants the right to counsel in any case where any term of imprisonment is going to be imposed. So here in this case, the Supreme Court said, no, this uncounseled tribal court conviction is valid. Why? The court walks through a well-settled doctrine of federal Indian law where tribes, as pre-constitutional sovereigns that weren't a part of the constitutional process, becoming members of the ratification of it, are not subject to the Constitution's limitations. So the Sixth Amendment doesn't apply. The court then looked at this Indian Civil Rights Act, which is a congressional statute that brought in some of the constitutional protections afforded outside of the tribal context. And the Indian Civil Rights Act is clear about the imposition or the requirement to a public defender for a term of imprisonment that exceeds a year. But any term of imprisonment that is below 1 year, right to counsel is not required. So all of the convictions that related to Bryant didn't impose sentences that were over a year. He did not have counsel, and Bryant's uncounseled convictions then accorded with ICRA. So the court relied on a decision, Nichols, that essentially stood for the conclusion that convictions that are valid when entered retain that status when invoked in subsequent proceedings. Importantly, in Nichols, the defendant pled guilty to a federal felony drug offense and before received an uncounseled conviction for a misdemeanor sentence, a DUI case. That uncounseled conviction previously, that just was an imposition of a fine, then served as a predicate offense that increased the limitations or the sentencing by 2 years. So in that context, the court really bootstrapped Nichols into this context and said, well, under Nichols, a valid conviction can serve as the basis for 117. So those are the legal bases, but importantly, the court really dug into some of the underlying bases, what drove the Violence Against Women Act and their decision here. You know, Bryant really represented a classic repeat offender in Indian country. And so his record included over 100 different convictions for various things, many of them assaults. And within the relevant time period, 10 years, included 5 domestic assaults. The court did articulate these statistics that represent this kind of, this awful situation that is occurring in Indian country relative to domestic violence. 46% of Native women have been victims of domestic violence. and Native women are 2.5 more likely to be assaulted or raped than women in general. So the court also describes the gap of authority that existed in Indian country at the time that this new statute, VAWA, was passed or amended. And so at that time, the sentencing authority of all tribes, no matter what, was limited to 1 year. VAWA itself amended the Indian Civil Rights Act and provided the sentencing authority if tribes provide certain procedural safeguards, including public defense. But at the time, it was only 1 year, and that, in the court notes, is not enough time to really offer a proper deterrent. The court notes that states, in particular Appeal 280 states that have criminal jurisdiction in Indian country, were unable or unwilling to fill the enforcement gap and didn't devote their limited resources to addressing this issue. So Congress stepped in. And the court didn't quite take the same swipe at the feds that it did at the states, but it did note that the feds really only had jurisdiction over major crimes resulting in serious injury or death. And so these types of domestic violence, misdemeanor domestic violence crimes, the feds weren't picking up and they weren't prosecuting. So this provided a tool for the feds then to reach down and say, all right, well, even if it doesn't involve a serious injury, we can still go after these folks and address the situation. Also important is that the court rejected Bryant's argument that tribal court uncounseled convictions are categorically unreliable and that tribal courts are categorically unreliable and unfit to render proper convictions. And the court rejected that, and specifically the quote is that there's no reason to suppose that tribal court proceedings are less reliable when a sentence of a year's imprisonment is imposed than when the punishment is merely a fine. And this is something that is a great boon and a sense of encouragement for tribal courts in the sense that the Supreme Court is recognizing and establishing a sense of comity and respect for tribal courts as institutions in addressing crime within Indian country despite the limitations that they face. So, the practical considerations, I'm so grateful to work where I work, and some of the projects that I'm able to work on bring me right down to work with tribal courts, work with tribal prosecutors, and leverage some of these principles and some of these decisions and learn how other people are leveraging these decisions to address crime in their communities. So tribal prosecutors, both lay and law trained, are specifically, they're very keen to this decision and are now, incessantly tracking who the repeat offenders are and pushing them to the U.S. attorneys in their area. And conversely, U.S. attorneys have now renewed an effort with renewed vigor prosecution of crimes in Indian country as well. So there's long been tribal liaisons from the U.S. Attorney's offices to tribes, but those liaisons are now better equipped and targeting, I suppose, in a more vigorous way these types of crimes. So now that there's a hook for curbing these types of misdemeanor domestic violence crimes, the U.S. Attorney is paying attention to what the tribal prosecutors are bringing to their offices, especially with a settled decision like Bryant. Of course, VAWA also represents heightened scrutiny by the federal courts over what tribal courts are doing, especially in the context of criminal convictions. This will obviously continue as tribes begin to or continue to exercise jurisdiction over non-Indian defendants who commit crimes of domestic violence. The U.S. Public Defender's Office has are consistently challenging tribal court convictions both under the U.S. Constitution and ICRA. And there are a number of decisions that are coming out that are not all favorable necessarily to tribal interests, but tribes are responding appropriately. And tribes are in a sense, they're confident. They're confident in their systems, and they're confident that these challenges will will not succeed. And in terms of the special domestic violence criminal jurisdiction provisions, a constitutional challenge is inevitable. But so far, despite renewed and continued persistent efforts to get defendants to bring a habeas challenge to a proceeding in tribal court under VAWA, these defendants have chosen not to. Perhaps they're more comfortable with the sentence they received in tribal court. I just wanted to talk a little bit about what courts are doing in terms of providing public defense to their defendants. Courts are acutely aware in terms of building trust and legitimacy within their community that it's important to provide a voice to people that are subject to the court's power. And in terms of those kinds of efforts, probably the most predominant effort is tribal lay advocates. These are lay advocates, and what we say is that 75.6% of all tribal courts, a survey conducted in 2000, employ a tribal advocate, lay advocate system. These are people that are trained and licensed to practice in their own forum. These are people that have been doing it for a very long time. They're people that are appointed to represent people, individuals in the community because they know that community. They're trusted. Of course, these are small communities, so everyone knows who the defendants are, who the victims are, who the families of the defendants are, what the history is. And because they're from the community, often rural communities, they remain there and they continue to work year after year as advocates in the court system. Some are considered tremendously successful, some aren't. What's important is how the lay advocate is, the role that they're playing as more and more courts start to invest in public defenders. So plenty of courts are now moving towards establishing a public defender system, whether contracting with individuals within the region or establishing an actual office. It's fully staffed. And some tribes are providing public defense in the same way that counties are. Some tribes are targeting certain offenders and certain offenses and providing public defenders for those, and then lay advocates are supplementing for the difference. The lay advocate is, in that circumstance, this hybrid model is playing an interesting role in terms of providing what some call like a holistic public defense model, where lay advocates are more and more taking on the role of more of the social work aspect, connecting defendants to resources, and making sure that some of the root problems are being addressed. I think that for the sake of time, I'll stop, but I will say that there are a number of innovative programs in terms of addressing public defender rights in tribal courts, and they serve as a model for each of us to be aware of going forward as our own jurisdictions address funding gaps, and we search for solutions to address the needs of public defenders. Excuse me, of defendants. So, we take questions. You should take the helm. Okay.
Questions, anybody?
One of the things that Michael had spoken about with public defense models is that is really being encouraged and helped by the United States Department of Interior, and he and I both work as contractors for their Office of Tribal Justice, consulting with tribal courts about their structure and operations, and there's funding available specifically targeted to filling funding needs to implement VAWA and Tribal Law and Order Act requirements. So not only getting codes in place and enhancing tribal lay advocates, but also letting contracts to surrounding attorneys and to regional public defense offices to provide the counsel defense that the court is looking for in the VAWA cases.
The Dollar General chronology really does look like Bleak House. But there was one thing I kind of puzzling about the chronology. Did Dollar General get an injunction of some sort staying the tribal court proceedings after The tribal court denied the Rule 12 motion and the tribal Supreme Court affirmed.
The Dollar General in their first filing in federal district court was for an injunction, and it was not granted.
Then why didn't the tribal court proceeding go on and the 13 or the 15-year-old get a verdict?
Yeah, it's an interesting question. I think that my sense of the situation was that with the tribal jurisdiction challenged, that the tribe decided to address the challenge, and the court decided to stay its hand until the jurisdictional issue had been resolved. But they absolutely could have gone forward. There was no injunction issued by either the tribal trial court or the tribal Supreme Court or the federal district court denied the first filing of Dollar General, which was for injunctive relief, and then granted the cross motions for summary judgment. Those came about 4 months after the initial filing. It is a gap, isn't it? If you look at it and you scratch your head.
I'm just curious now that it's going back to the tribal court, are the timelines in a trial in tribal court similar to what we see in district court?
It's a good question. You know, the dockets of tribal courts, I've been advocating for lawyers in the state of Minnesota to use where they can tribal courts, because their dockets tended to be lighter, and on commercial disputes you can get an adjudication more quickly than you might in another court. This court has a big docket, and the timelines for processing under the tribal code, you know, deadlines for filing, you know, dispositive motions after discovery, and the timelines for discovery and pretrial filings and setting a trial date are all fairly parallel to what you would typically see in a state court. I don't know that they have the mandatory initial disclosures or not. I think their discovery tends to still be the ask for it and you'll receive it rather than mandatory disclosure. So I think the timelines are pretty consistent in that court. And I didn't find out whether where they are in the tribal court proceeding. If I were Dollar General, I probably would have sought a stay for mediation, but I don't know that to be the case. Yes.
I remember you said that it was odd to see Montana apply to trust land
Yeah.
in Dollar General. Since the Fifth Circuit decision stands, the Fifth Circuit decision is applying Montana to trust land, right?
Yeah.
Are there other circuits, to your knowledge, that have done that, or is it still mostly about fee land?
It's the test still as it stands, and that was one of the challenges raised in Dollar General, was whether it extends to trust land. And so, yeah, I mean, the Fifth Circuit will stand for a number of good things, but it also is an application of Montana to tribal trust land. I have not seen an application of Montana to conduct on tribal trust land that I'm aware of in the other circuits. Yeah. I believe maybe in United States versus Hicks there may have been a subpoena that covered records on tribal trust land. Yes?
In the last couple of years, the U.S. Attorney's Office, I guess, got involved in the dispute in San Anthony with the mosque and the zoning for denial of it from a building there. And they got involved, I suppose, with Judge Michael Davis as well, in using defendants in one case and turning them around as spokespersons against sort of the trap they've fallen into, if you want to put it that way. With the increased work with the U.S. Attorney's Office and restorations since Bryant, is there any indication that there might be an opportunity for maybe community involvement or creative programs?
Yeah, I think so. I think since the Tribal Law and Order Act and the Violence Against Women Act, there's been really constructive federal to tribal relationships that have been forged. What I'd say, though, is that many of the advocates I work for in Indian country have been asking for this for a long time. There's no one to flip in this circumstance. And so this has been a renewed effort that I think that, an effort that's been ongoing and is now in some way there's a drip that's satisfying that thirst. I would add too that the Tribal Law and Order Act, especially with respect to PL 280 states, have brought in a lot of, have forced and forged really awesome relationships between the feds, the counties, and the tribes, and they're addressing criminal jurisdiction. I'd say here, especially White Earth, as comes to bear. So there's a lot of unintended or perhaps intended consequences of real decision making and problem solving between prosecutors. Yeah.
Thank you.